Hello viewers, I am Dr. Wajda Rahman. Today we will discuss marriages among Muslims under the law relating to Muslim marriage. The main objective of this module are to know about the legality of Muslim marriage, to know about the essential conditions under Muslim law relating to marriage, to know about the rights and duties emerging in marriage among Muslims. Let's introduce the topic. Marriage has a significant role in Islamic jurisprudence. Amir Ali, a legal expert, argues that a Muslim marriage is a social institution designed to enhance society and protect individuals from moral degradation and sexual impropriety. Marriage is the act of uniting two individuals in society. In Islamic governance, the marriage contract known as Nikah is seen as a civil agreement that mainly attempts to improve the well-being of the parties participating. Under Sharia law, a written document is not strictly required to prove the existence of a marriage contract. However, for a Muslim marriage to be recognized, it is necessary to have a legally binding agreement. The Holy Quran and Hadith provide comprehensive guidance on the institution of marriage with intricate directions. Marriage creates the structure for the family and organizes the primary building blocks of human civilization. The continued existence of the human species relies on robust families. In Islam, marriage is seen as a societal establishment and the conjugal bond that enables a man and a woman to engage in sexual intercourse for the purpose of forming a family, cultivating an affectionate relationship, assuming parental roles, and providing mutual assistance. Families are seen as the fundamental constituents of society. Islam, like Hinduism, is a faith that strongly supports and encourages marriage. Nevertheless, Hinduism sees marriage as a sacred ritual rather than a mere contractual exchange, resulting in a distinct understanding of marriage compared to Islam. In order to satisfy the legal requirements of becoming a parent, one must be in a legally recognized marriage. The principles of Muslim law have been formed from a diverse range of sources, both codified and uncodified. These sources include the Quran, Ijma, that is consensus, Qiyas, that is analogical reasoning, conventions, precedents, equity, and other relevant sources. Now, let's discuss the essentials of Muslim marriage. A Muslim marriage, also known as Nikah, must satisfy the specified general requirement. Number 1, the capacity to enter into marriage is essential. The proposal, known as ijab, and the acceptance, known as kabul. Unconditional agreement from both parties. A dower to the bride, that is the meher. There must not be any legal impediments. Adequate witnesses that are distinguishable under Shia and Sunni jurisprudence. The parties must have the necessary capacity to get married. Every procedural requirement must be completed with precision. It is necessary to have voluntary agreement from both sides without any coercion or manipulation. It must not be subject to any kind of legal limitation. A Muslim marriage, Nikah, must adhere to the legal prerequisites. The necessary legal components that must be present for a Muslim marriage to be considered lawfully. The proposal and its acceptance. As previously said, Muslim marriage is considered a kind of civil contract. Therefore, the proposal and approval are important. The phrases ijab and kabul represent the act of making a proposal and accepting it, respectively. One party should propose and the other party should accept the suggestion. Furthermore, it is optimal to finalize the proposal and acceptance within the same meeting. The competency of the parties. A. Age of marriage. In Islamic weddings, the age at which individuals may be married is regulated by their attainment of puberty. Hedaya asserts that the onset of puberty typically occurs at the age of 9 for females and 12 for boys. In the case of Muhammad Ibrahim versus Atika Begum and another, that is 1912, the Privy Council determined that the suitable age for puberty is 15 years. At this age, individuals have the autonomy to make decisions without relying on their guardian's approval. B. Sound mind. If either party is mentally ill, they are ineligible to engage in a marriage contract. Consequently, it is essential that both participants possess sound mental well-being while engaging in such activities. C. Consent. In order for a marriage to occur, it is necessary for both individuals involved to give their permission. This authorization may be granted willingly or implicitly, but it cannot be obtained via deceit, force, fraud, or any other unjust means. If permission for a marriage is acquired by deceit, it is considered illegal. However, if the consent is based on a factual inaccuracy, the marriage is considered invalid. In 1939, in the case of Mohiuddin versus Khatiza Bibi, a girl who adhered to the Safi school of thought was compelled to enter into a marriage without her consent or approval, as imposed by her father. The Bombay High Court declared the marriage to be null and void. A marriage is contingent upon the mutual consent of both the groom and the bride. In order for the agreement to be valid, the woman needs the presence of a guardian or representatives. The objectives are to be safeguard her rights and maintain her modesty. In Islam, it is permissible for a man and a woman to have supervised interactions and conversations before marriage. In order for a marriage to be considered legal, it is necessary for consent to be freely provided. Consent is considered invalid if it was obtained by deceit, mistake, or coercion. The marriage is not considered legal unless the adult partners provide their voluntary permission. According to Sunni custom, it is necessary to have two male witnesses present at the marriage ceremony. D. Dower. It is also referred to as meher. Dower refers to the monetary or material assets that a husband offers to his spouse as a gift during the marriage ceremony. Wives possess the legal right to request dower from their husbands. The dower or meher is a mandatory gift given by the husband to the wife. It is also mentioned in the Holy Quran, chapter 4, verse number 25. This amount must be commensurate with the husband's income. During the marriage ceremony, the specific amount of dower is announced. The payment may be made either in installments or in full as a lump sum. Once bestowed, it becomes the exclusive possession of the wife, giving her unrestricted authority to use it as she desires. Both parties should be able to reach a consensus over the quantity. If the groom is financially disadvantaged, he may choose to impart his knowledge of the Quran to his bride as a kind of dower. In the case of Nasra Begum versus Rizwan Ali, that is 1980 case, the Allahabad High Court established that the right to dower arises before the commencement of the cohabitation. The court also established that if the woman is a minor, her legal guardians have the power to refuse to deliver her to her husband until the dower payment is made to her. If the lady is already under the husband's supervision, she might be sent back until the payment of the dower is settled. Now, let's discuss the prohibition. Certain situations prohibit certain marriages from being allowed under Muslim law. These forbidden classifications are separated into different sections. Number 1, soundness of minds. Partners are deemed competent for marriage only if they are both mentally healthy at the time of the marriage. A person who is mentally unstable lacks the capacity to enter into a marriage contract. Therefore, their consent is not considered valid. Consequently, the guardians of a mentally ill person may enter into a marriage contract on their behalf during periods of clear thinking, when they are aware and able to understand the requirements and complexities of marriage. However, the marriage of an intellectually disabled person is considered void and illegal since they are incapable of providing their consent. Next, religion. Another essential aspect of Muslim marriage is the need for both parties to be practicing Muslims at the time of marriage. A Muslim woman is restricted to marrying a Muslim man exclusively, and it is not permissible for her to marry a non-Muslim. Any marriage that violates this condition is considered void and invalid. An interfaith marriage between a Muslim man and a woman of a different religion is considered non-traditional. It is feasible to eradicate the irregularity in the process of female conversion to Islam. Now, let's discuss the formalities of Muslim marriage. The following requirements of a valid Muslim marriages are compulsory. Number 1, a proposal must be made and accepted by both parties. In Sunni law, a marriage cannot be deemed lawful unless 2 witnesses are present. Typically, there are 2 male witnesses to the marriage, but 2 female witnesses are also possible if there are no male witnesses. The marriage will become irregular if this formality is broken. The witnesses had to be adults, Muslims, and of sound mind. Next, a legitimate marriage according to Shia law does not require the presence of 2 witnesses. Nonetheless, the parties must sign the nikahnama in front of them. The wife must get the dower or meher. The marriage should not be subject to any legal disabilities. The marriage should not be subject to any legal restrictions or limitations. Now, let's discuss the legal prohibition of Muslim marriage. As we have discussed earlier, a valid Muslim marriage must be free from any kind of impairment or restriction. There are 2 distinct sorts of restriction on Muslim marriage: absolute prohibition and relative prohibition. If a marriage is entirely outlawed, it is deemed void. Nevertheless, in the case of a partial prohibition, the marriage is deemed to be irregular and may potentially become legal if the irregularity is rectified. Absolute prohibition. In a Muslim marriage, individuals are prohibited from marrying if they are blood relatives or if they fall under limited degrees of kinship. Marriages of this kind are severely prohibited, and if they take place, they are deemed null and void. Absolute prohibition arises from the following associations: consanguinity, that is qurabat. It encompasses all biological relationship based on shared blood. Incestuous marriage is forbidden for a guy. Examples of such connections include maternal or paternal figures such as his mother or grandmother, direct descendants such as his daughter or granddaughter, and extended family members such as his niece. Next, affinity, that is musharat. A marriage between closely related persons is also prohibited. Example, the female relative mentioned include the grandmother on the mother's side, the daughter, the stepmother and the daughter-in-law. Next is fosterage, that is Riza. When a child is breastfed by a woman who is not their biological mother, that woman becomes their foster mother. He is forbidden from marrying his foster mother or foster sister. This is explicitly prohibited. Relative prohibition. Some restrictions in a Muslim marriage are relative, which means that if a marriage is done in violation of this prohibition, it will be regarded as irregular rather than invalid. There are several categories of relative prohibitions. Such encompasses unlawful conjunction is the act of forbidding a man from marrying two women who are related to each other via blood, marriage or fosterage. This kind of marriage is prohibited according to Islamic principles. This precaution is being adopted to prevent any possible misinterpretation of linkages that include both familial ties and multiple responsibilities. Under Islamic law, polygamy is restricted to a maximum of 4 spouses for Muslim man. If he chooses to wed a fifth lady, the marriage will be deemed irregular and may only be acknowledged if he ends one of his preceding 4 marriages. The absence of suitable witnesses is a critical determinant of a valid marriage in the Sunni tradition. A marriage done without witnesses is considered irregular. However, under Shia law, the presence of witnesses is not compulsory. Religious discrepancy. A Sunni male is allowed to marry a Muslim lady from any sect or a Kitabiya, but he is not allowed to marry an idolater or a fire worshipper. According to Sunni law, these marriages are deemed irregular, and according to Shia law, they are regarded as invalid. Marriage during the iddat period refers to the act of entering into a new marriage while the lady is still in the period of seclusion after the end of a previous marriage. Marriage with a woman during her iddat period is prohibited. Marriages that occur during this period will be deemed irregular according to the Sunni tradition and invalid according to the Shia tradition. Now, let's discuss the matrimonial registration in Islamic law. As Muslim weddings are considered civil agreements, it is necessary for Muslim marriages to be officially recorded. Section 3 of the Jammu and Kashmir Muslim Marriages Registration Act of 1981 declares that every marriage between Muslims that take place after the start of this act must be registered within 30 days after the Nikah ceremony. The Nikahnama is a legal document in Muslim marriages that contains essential terms and information for the marriage. Nevertheless, in instances where the legal presumption of marriage is not automatically granted and its validity is being questioned, it would be necessary to provide strong proof using the normal method to show its existence. In such scenarios, any written document would have great importance. According to the Muslim Family Law Ordinance 1961 in Pakistan, it is required that every marriage performed under Muslim law be registered in accordance with the requirements specified in this ordinance. In India, there is no legal need for compulsory registration of a Muslim marriage with any governmental entity. It is important to mention that In the states of Assam, Bengal, Bihar and Odisha, there are local regulations that permit the voluntary registration of Muslim marriages. It is crucial to emphasize that the Qazis maintain a register to document the details of the marriages they have presided over, in the event of any mishappenings or shortcomings. Every marriage record is properly signed by the couple, their guardians or representatives, the witnesses and the Qazi. The Qazi often distributes duplicates of the document, also known as Nikahnama, to the individuals concerned. A Nikahnama must include the following particulars. Number 1, the precise geographical coordinates and specific characteristics of the wedding venue. The complete name of the groom, his age, his residential address, the complete name of his father, the status of his father's existence, whether he is alive or not. The groom's marital status at the time of marriage, indicating whether he was unmarried, widower, divorced or currently married, and if married, the number of his remaining wives. The groom's signature or thumbprint, regardless of whether the Nikah ceremony was performed in person by him or via his representatives or guardian. The Nikah Khan is responsible for conducting the Nikah ceremony. The Nikah Khan's signature, consisting of their name and the date of the Nikah ceremony. Fix dower amount, dower payment method, names, addresses and places of residence of witnesses. In conclusion, the institution of Muslim marriage has great significance and must meet some essential conditions in order to be considered valid. The conditions for marriage consist of the fundamental requirements of mutual agreement, meeting the legal criteria for marriage, the exchange of marriage proposals and acceptance in a single gathering, and the presence of witnesses who are legally certified. Preparation for the dower are crucial since they guarantee the bride's financial stability. Rules are implemented to prevent marriages that are deemed illegitimate because of consanguinity, affinity, guardianship and other pertinent circumstances. Although not obligatory under Islamic law, registration is considered crucial for documentation in several fields. The fundamental requirements for a legitimate Muslim marriage highlight the sacredness of marriage within Muslim society, placing significant emphasis on the concept of consent, capability, and commitment to Islamic norms. This serves as a method to guarantee the protection of societal principles and the safeguarding of the rights of all involved parties. That's all for today's lecture. I hope you have enjoyed the lecture. Thank you very much.